There are other items on the ballot this year as well. We've already talked about Constitutional Amendment number 2, which would pave the way for an independent ethics commission. But there's also Constitutional Amendment number 1, which has to do with potential changes to how minor court cases like traffic violations are appealed in New Mexico. I recently sat down with an expert to find out how those changes would work and why the amendment is just the first step in the process. Joining us today is Artie Pepin. Artie is the director of the Administrative Office of the Courts. Welcome.
Thank you.
Thank you for being here. I want to start very briskly on what this amendment would do. If I understand this correctly, basically it would completely change the way cases in probate, magistrate, and metro courts are appealed. How is that situation done now? And we'll get into what would change with the amendment, but how is this situation handled currently?
Currently, cases that come out of the limited jurisdiction courts, they're called inferior courts in the Constitution, go to a district court, a trial court, on appeal, including the cases that come out of the Metropolitan Court here in Albuquerque that are heard on the record, domestic violence or DWI cases. And then from the district court, they can be appealed to the Court of Appeals and then ultimately to the Supreme Court.
Now, what's different? Well, let me ask you this first. A lot of appeals, as we know, go first to the district court, right? And then for intermediate rulings, this would allow cases to go straight to the Court of Appeals instead. If I have that, is that correctly? Am I stating that correctly?
Yes.
Okay. Flesh that out a little bit. What's the changes that happen here?
So the Constitution right now makes it impossible to send those cases directly to the Court of Appeals, even when they're on the record cases, right? They have a trial, you can have a jury trial, and they can't go to the Court of Appeals. Because the Court of Appeals and the limited jurisdiction courts were created after the Constitution came into existence, that's why it's written that way. But because we have record cases, for example, in Albuquerque, it makes a lot more sense for the cases to skip the district court and go up to the Court of Appeals.
Gotcha.
Now, the amendment itself doesn't require that happen. It just allows the legislature to enact a statute that changes the statutory way the appeals flow.
Right.
The statute that exists right now follows the Constitution and has them go from Metro Court to the District Court to the Court of Appeals.
And again, if I have this correct, the change would be you could skip that process and go straight to the appellates could go straight over district court and go straight to the Court of Appeals.
Right, so the misdemeanor cases and the civil cases that are on the record, which are cases involving $10,000 or less in Metro Court, for example, would go to the district court, to the Court of Appeals, just like the cases that are heard in district court that involve $100,000 or felonies, kidnapping, they go to the Court of Appeals. So all of them could go to the Court of Appeals if that's what the legislature decided.
Gotcha. And does this help out with the backlog that we see in district court around our state? Does it, and instead of having to muck with cases that are under that threshold you just mentioned, does this free up those folks markedly?
It certainly will reduce the number of cases that the district court has to handle because in addition to their regular trial load, which is heavy, substantial, they have to do these appeals. And the Court of Appeals, that's what they're designed for. There's 10 judges there and they're supposed to do appeals and they're very good at it.
Right. Where did this idea come from originally? What was the impetus here? Was there a specific case or was there a specific series of cases?
The judiciary went through a process we call re-engineering a few years ago and looked at everything we do and are there ways we could do it better. This was one of those things. It's not a major thing. It's not the biggest thing in the world, but it's important, we think. The idea surfaced as part of that re-engineering focus. We went to the legislature and we're glad that in 2017 it got traction on this. There was a case that went to the Supreme Court in 2016 on this exact issue, and they said, unless the Constitution is changed, the cases go to the district court before they come to the Court of Appeals, and you have a right to go both places on a misdemeanor, on a DWI, whereas you only have the right to go to one court on a felony, like a kidnapping or something.
Yeah. Interesting that you just said that because does this not have the potential to shift some of the burdens that the district courts are struggling with now to the appellate court? Is there a potential that one less burden ends up someone else's burden down the road?
Yes, that's the intended effect, in fact. If the legislature passes a statute and the governor signs it, it would shift some work from the district court to the Court of Appeals. But there are a couple of good reasons for that to happen. First of all, the district courts they're designed to do trials. So you go down to the district court and you'll see judges making rulings on motions and conducting trials and impaneling juries and things like that. These cases are cases where there's a record, it's already been decided, and the way you look at an appeal is very different than the way you look at a trial. The rules are different, the standard you apply is different, and that's exactly what the folks up the hill here in Albuquerque at the Court of Appeals and in Santa Fe, that's exactly what they do every day. They apply an appellate standard of review, they look at whether the judge was right or wrong in making a decision about suppressing evidence or something. And it's a very different work. And some work will move from district court to the Court of Appeals, but they're suited for that.
But again, could it potentially overburden the Court of Appeals with this situation?
We certainly don't think so.
Okay.
If there were a need for more resources in the Court of Appeals because of this, and we certainly don't think so with regard to the cases that come out of the Metropolitan Court, which is the most likely place the legislature would make a change, probably there wouldn't need to be any more resources. But if there were, there are staff folks, attorneys, in the Second Judicial District who do these appeals, make recommendations and review them for the judges. And we could shift those resources to the Court of Appeals if there was a need there. But we don't think it's not a huge volume of cases. It's not, and because the Court of Appeals does this routinely, it's easier for them to do it than it is for the district court.
But it is different processes, certainly.
Oh, yes.
And for the appellate court, it's not things like retrials or anything. You know what I mean? So again, I'm just as a layperson here, that does not cause any problems potentially for the appellate court folks that even though their processes are quite different, they get things landing on their lap that they have to deal with.
No, because it's the kind of things that come to them anyway.
Okay.
So, for example, the same case that gets appealed to the district court that the district court finally decides on, that case gets appealed to the Court of Appeals. It's exactly the same as the one that got appealed to the district court because the record that comes from Metro Court goes to the district court and they do their thing with it. And then any party in the case can then appeal that to the Court of Appeals. So it's the exact same case. It's just we're asking the district court to do two different things as opposed to the appellate court doing one thing, which is what it does routinely.
Gotcha. But a new situation sometimes requires new training, a new way of looking at things. This costs money. This costs time. Do you feel like the legislature could potentially be in a position to see those issues as well at the same time they're looking at this?
Certainly the legislature will ask us. If we propose to the legislature or if a legislature says, well, now that the people in their wisdom have adopted this constitutional amendment, we should make a change in Albuquerque for the Metro Court cases on the record. What kind of resources are you going to need? Are you going to be coming to us saying you need another staff attorney? Heaven forbid you need a new judge, And we've looked at the data and we've examined the workload of both the district court, the Metro Court, and the Court of Appeals, and we're pretty confident the answer would be no.
Okay.
But we'll give them an honest answer. That's our job, and it doesn't do us any good not to give them an honest answer.
Right.
But we really think not. But if we did, if they propose a statute maybe in a way we didn't anticipate and it did require something new, we would tell them, yes, we'll need whatever it is we would need.
Right. My last question, and sort of an obvious one, again, a layperson's question, you have to forgive me a little bit, but the judicial branch is certainly its own separate form of government, but we've got another branch of the government deciding what you folks can and can't do, meaning the legislature. For a lot of folks, that seems kind of odd. Are you comfortable with how this is? I mean, it's our process, it's what we have to do, certainly, but are you comfortable with how the legislature being able to handle this process and come out with an appropriate result?
Absolutely. We talk a lot about the independence of the judicial branch, but that kind of independence is the independence to make decisions based on the law, the Constitution, without interference from the other branches of government. Gotcha. When it comes to appropriating money for the judicial branch or determining if we get another judge here or there, those kinds of things, allocating resources, it's perfectly appropriate for the legislature to make that determination. And because the Constitution sets out the kind of the framework in which this all works, we're very comfortable with us, that is the judicial branch, having to go to the legislature and say, now that the amendment allows you to do this, we think this would be a good idea for you to take advantage of that authority given to you by the people who voted for the amendment. And certainly talk with Senator Wirth and Representative Maestas, the sponsors of the amendment, and I think that they would be inclined to do something reasonable. And if they weren't, okay, we'll continue with the system we have, and it's a good idea to have balanced authorities among the branches of government.
That makes sense. Artie Pepin, thank you so much for coming in.
My pleasure to be here.
It's an important amendment. We want to get the information, and you supplied it.
Thank you.
Thank you so much.